Welcome to This Explainer. You know, when most of us picture a civil lawsuit, our minds instantly go to TV drama. We imagine lawyers pacing around a courtroom, passionately yelling at witnesses, and, of course, those sudden, shocking confessions on the stand. But the actual reality of civil litigation, especially in South African law, is quite different, and honestly, it's a lot more fascinating. It isn't a chaotic shouting match, it's a highly structured paper war. And that war begins not with some dramatic opening statement, but with two critical, carefully crafted documents. Today, we're going to break down the anatomy of a lawsuit by looking at exactly how the initial attack and the inevitable defense are constructed. Here's our roadmap for the explainer. First, we'll look at the basic anatomy of a lawsuit. Then, we'll step into three distinct rings of South African law: broken contracts, delict and damage, and divorce disputes. Finally, we'll wrap it all up with the final tally.
Okay, let's dive into this. Part 1. Anatomy of a lawsuit. The opening bell.
To really understand how any civil dispute plays out in the High Court or a regional magistrate's court, you need to know the fundamental building blocks. These are the documents swapped right at the very beginning of the process that tell the court exactly what the fight is going to be about. The first document is called the Particulars of Claim. Think of this as the attack. This is written by the plaintiff, the person actually bringing the lawsuit, and it's basically their opening volley. It does a very specific job. It has to meticulously set out the facts of what happened, the legal reasoning behind why they're suing, and finally, exactly what they want the court to order the defendant to do. That might be demanding a sum of money, a formal divorce decree, or an order to perform a specific action. It literally lays all the cards on the table.
Directly countering that attack is the second document, the plea. This is the defense. And here is where South African legal procedure gets super structured. A defendant cannot just hand in a piece of paper that broadly says, "I disagree, this is ridiculous." No way. They are forced to engage directly with the attack. They have to go through the plaintiff's particulars of claim, paragraph by tedious paragraph, and do one of three things. They must either admit the fact, deny the fact, or use a really fascinating legal strategy called confess and avoid. That basically means admitting a fact is true, but providing a legal excuse as to why they shouldn't be held liable for it.
Round 1. Broken contracts.
So, how do these documents actually battle it out? Let's step into our first metaphorical boxing ring: breach of contract. This is the legal avenue you take when a binding agreement between two parties gets broken. When a plaintiff throws that first punch, their particulars of claim must contain a rapid-fire sequence of requirements. Step 1. Prove a valid contract actually exists. Was it written or verbal? When and where was it signed? Step 2. List the exact terms of the contract relevant to the fight. Step 3. Detail exactly how the defendant breached or broke those specific terms. And Step 4. Calculate the financial loss, the damages, suffered as a direct result of that broken promise. Now, what's really interesting about this slide is how the defense brilliantly responds in their plea. A hypothetical defendant might say, "I admit the contract exists, but I deny that I breached it because the goods I delivered were perfectly fine." Notice the strategy here. The defendant isn't wasting time arguing over whether they signed a piece of paper, they just admit to Step 1. Instead, they focus all their defensive energy on Step 3, flatly denying the breach itself based on the quality of the goods. It brilliantly narrows down exactly what the court will have to investigate.
But sometimes, the defense gets a little more creative with that confess and avoid tactic. The attack might simply state, "You breached the contract by not paying." The defensive counterpunch? "I admit I didn't pay, but only because the plaintiff failed to deliver their side of the deal first." Translated into everyday speech, the defendant is basically saying, "Yes, I completely confess that I didn't pay you, but here's my legal loophole to avoid liability. You didn't do your part first." It's a fantastic counterpunch.
Moving on to round 2. Delict and damage.
Let's leave contracts behind for a second and explore a very common arena in South African law. In simple terms, a delict happens when someone wrongfully and either intentionally or negligently causes you harm or damage. If you get into a car accident because someone wasn't looking, or if you slip and fall on a wet floor at a grocery store because there was no warning sign, those are delicts.
Building an attack in a delict case requires the plaintiff to clearly outline 4 specific elements in their particulars of claim. First, the wrongful act itself. For example, explicitly stating, "The defendant drove through a red traffic light." Second, the fault or negligence, stating the driver failed to keep a proper lookout. Third, causation, drawing a direct line from the act to the injury, like, "Because the defendant hit my car, my leg was broken." And fourth, damages, which is a detailed rand and cent breakdown of medical bills, car repair quotes, and even compensation for pain and suffering.
So the crucial point is, how does the defendant block this attack in their plea? A very common strategy is the absolute flat denial. The defendant simply states, "I deny that I was negligent. The traffic light was green for me." Just like that, in one sentence, they attack the very foundation of the plaintiff's case. If the light was green for the defendant, there is no wrongful act, there is no negligence, and the entire lawsuit could just collapse.
However, DLIC cases often exist in a bit of a gray area, leading to a defense known as contributory negligence. The attack might demand full damages for the accident, but the defense argues, okay, even if I was negligent, the plaintiff was also negligent because they were speeding and not wearing a seatbelt. Therefore, damages should be split. The defense is essentially arguing that even if they threw a bad punch, the plaintiff tripped themselves up. They're asking the court to assign a percentage of the blame to both sides, which directly reduces the amount of money the defendant ultimately has to pay out.
Round 3, divorce disputes.
Now for our final and undeniably most personal round. Because a divorce literally changes a person's legal status, it requires specialized paperwork. The divorce particulars of claim, usually attached to a summons, lays out the cold, hard facts, when and where the marriage took place, and exactly how their assets are legally tied together. It lists the names and ages of minor children, then it states the legal ground for divorce. In South Africa, this is almost exclusively the irretrievable breakdown of the marriage, meaning the parties don't live together and there's no love left to save. Finally, it ends with the prayer, which is the plaintiff's list of demands regarding who gets primary care of the kids, what maintenance must be paid, and how the physical assets will be split.
And this brilliantly illustrates the reality of most divorce litigation. You see, in their plea, the defendant very rarely fights the fact that the marriage is over. They usually just admit to the irretrievable breakdown. Instead, the battle lines are drawn entirely around the prayer. A defendant might aggressively fight the financial terms, stating, "I deny that the plaintiff needs our $10,000 a month in spousal maintenance because they earn a good salary." The emotional relationship is legally conceded, but the financial relationship, that is heavily contested.
And of course, the fiercest battles occur over custody. The attack might feature the plaintiff demanding sole primary care of the children, while the defense pushes back, arguing it's actually better if the children live with them instead. What you'll notice in divorce law is that both sides frame their sparring around the exact same legal standard, the best interests of the children. The court is left to read these conflicting documents and try to decide which party's version of reality actually serves the children best.
Let's move to the end and see how this all builds up. Part 5, the final tally.
Putting these 3 boxing matches together side by side completely demystifies the dense legal jargon. Just look at this summary. In contract law, the court attack is simply, "We had a deal, you broke it, it cost me money." And the court offense is, "I didn't break it," or "You broke it first." In delict, the attack is, "You were careless, caused an accident, and I got hurt." The defense counters with, "Not my fault," or "Partly your fault too." And in divorce, the attack states, "The marriage is over, let's split things my way." While the defense agrees the marriage is over, they counter with, "Your split is unfair." When you strip away all the Latin phrases and the stiff formalities, civil litigation is really simply a highly structured conversation between 2 fundamentally opposed viewpoints.
So, what does this all mean? When you understand that a lawsuit is fought first and foremost on paper, through the careful drafting of the particulars of claim and the plea, it raises a pretty provocative question. In the end, does the winner of a lawsuit just have the best objective facts, or do they simply have the best framed arguments? It's absolutely something to ponder the next time you hear about a major legal dispute. Thanks so much for joining me on this explainer. Keep questioning, keep learning, and I'll catch you next time.